What happens when you have an earnest money dispute in a commercial real estate transaction? Ron from Rohde Law, and in this video, we're going to talk through the sequence and procedure of events for when there's an earnest money dispute in a commercial real estate transaction, say for a multifamily property or an industrial property. What actually happens if the opposing side, let's say the seller in a situation, doesn't agree to release the earnest money and return it to the buyer? All right, guys, so I talk a lot about contracts. I talk a lot about different asset classes and how it's best for you as an investor. But today's video is going to be a little bit of an insight into the legal process. And just as a disclaimer, we're a transactional law firm. We help investors invest in commercial real estate and make money, but we're not a litigation law firm. And that means I'm not going to court. With that disclaimer out of the way, I have been through the process where I've observed for my clients as they go through the earnest money dispute process. So step number one, you need to make your notice. You need to make your demand. And that typically is invoking a certain section of the PSA that allows the buyer to terminate the contract and receive a refund of their earnest money deposit. So this can come at various times. I think the earliest is, or the most common is during the due diligence period. So this is the initial feasibility. Everybody understands that any soft earnest money or non-hard money is refundable during this period for any reason or no reason at all. So that's the first situation. The second would be after that initial due diligence period has expired, but prior to title objections being cured. So generally in the process, if you have a longer window for title objections, you may file those, and the seller typically has another period of time to respond to those objections, either that stating that they are going to cure those objections prior to closing, or that they refuse to cure, and then it comes back to the buyer to decide, am I going to waive those objections or am I going to terminate the contract? And so that's probably the second most common time that a buyer would terminate. And then the third is the last phase, which is at any point prior to closing, but after those deadlines or those mechanisms have expired. And this is where I think it gets a little bit gray area. So for example, depending on your PSA, you may have different clauses that allow the buyer to terminate the PSA for such issues like condemnation, casualty loss. We just had some storms here in Dallas. Let's say you're planning to buy this building, but a giant tree that weighs 4,000 pounds crashes down on the half of the building, taking out all of the windows in the front office. It's a significant event that is going to trigger insurance, and if it rises to the threshold as specified in the contract, the buyer may likely have an ability to terminate the contract and get their earnest money back through no fault of their own, no fault of the seller. But this is an act, an act of God that just occurs, but it allows the buyer to terminate. However, the seller may disagree with the buyer's interpretation and say, no, I don't think that this casualty event rises to the level of a terminable event. And they're going to disagree. They're not going to agree with title, or they're going to respond to your demand by denying your request and disagreeing. Instead, they're going to say, we will grant you an extension of closing. We will restore the property, but you still have to close. This contract is still live. So what do you do when that happens? So you send your demand. You have to read the contract to understand what is the proper steps. Who do you have to notice? And I say that again because sometimes you have to notice the seller as a party via email, via mail, certified mail, that sort of thing. But you may also have to notice their attorney, and it may be a required notice section. So you need to really make sure that your lawyer understands the notice provision and that you're not relying on any boilerplate or standard language. You have to check every contract for the notice requirements. So you send that demand, you receive their demand back. You usually, next steps, will make a demand to the title company and let them interpret it. However, 99% of title companies these days, they're going to be conservative. They'll send out a release of earnest money to both parties. If the seller doesn't sign or they refuse to sign, title typically won't release. They don't want to get involved in the he said, she said, and if they don't have signatures from both parties authorizing a release to one party, they're not going to release it. So what do you do? Again, I think I would follow up with a secondary demand to the seller and demand that they sign that as part of their cooperation, stating all of the facts, all of the elements that allow the buyer to terminate because of this event. If you have, again, I'm using that casualty loss as an example. If you have additional documentation on the amount or the severity of the damages, that's what you're going to need to justify your position. And you still want to pick up the phone and talk to the seller and say, hey, we have an out. The contract was very clear that if there's a casualty event exceeding $100,000 or $200,000 in repairable value, that the buyer could terminate. And I have invoices that show the damage estimate. I have written contractors who have gone through the property. The cost to repair this type of damage is going to be $500,000. I want to terminate. And that's really where your attorney can try to communicate and try to argue. What usually happens here is, I would say, is a settlement. So even if the seller believes that they can keep you under contract, in the interest of expediency and the fact that it's very hard to force somebody to close. You can't force them to come out of pocket. So other than losing the earnest money, you're not going to force somebody to buy your property. And so a lot of sellers realize that. And so they may negotiate to say, on a $75,000 earnest money deposit, I'll give you back 65. I'll give you back 70. In a way to just kind of grease the wheels, to cover some of their expenses and to avoid that. Depending on how hard or how serious the buyer is, they may take that. Just again, as a pure business decision, it has nothing to do with the law. I think legally in that situation, the buyer is entitled to 100% of the earnest money back. However, there is a little bit of this horse trading that can just get a deal done and a return of the earnest money if there's a genuine dispute about whether the money should come back, because it's going to end up in litigation, which leads me to my next step. Step 4, hiring a litigation attorney. Because at this point, if you've communicated with the seller, if you've sent all of your notices, if you've sent a valid termination, you have documented everything, there really isn't more steps that your transactional lawyer can do to solve this situation. You're going to have to file suit. You're going to have to read the contract to see where appropriate venue is, federal court, state court, what county. Usually it's going to be the county where the property is located, but don't assume that. State law will govern. So you need state court attorney typically. But that's going to be the next step. So you need to hire this counsel. They're typically going to want a deposit. You're going to have to deposit retainer money with them. They're going to send a demand. They may send a pre-suit notice, and then they'll file a lawsuit, and then they're going to serve it on the other party. And at this point, the case is really out of business maker's hand, and it's transitioned over to the court. The judge is going to rule on this, and they are going to decide how much earnest money, if anything, how much earnest money is going to be returned to what party. And so after you do that, you again can have a couple of scenarios depending on how hard the seller truly wants to fight. And what I mean by that is how much money and time do they truly want to invest in fighting this earnest money claim if they think in their heart of hearts that they're wrong and they don't really have a strong claim. So they can not answer, and they can take a default. Your attorney will still be required to obtain a default judgment and bring that default back to the title company, at which point usually the title company will release the funds. Caveat, unless upon notice of the suit, title will deposit those funds into a court registry so that they have completely wiped their hands of the money. They say, okay, you've filed suit, now we're going to deposit those funds in the court registry and our hands are done. So once you obtain a default judgment, the court will then release those funds to you directly. All in all, you're going to get your earnest money back minus all these legal fees, and you don't get any reimbursement. Let's say it costs $5,000 for that suit and default judgment. You may end up spending $4 to $5K in legal fees against your full earnest money return. Now that's the best case scenario. Second best would be you serve them, they file an answer, but they're pro se. It could be pro se, or they could just be filing kind of a weak answer, a general denial, and they don't really have their heart in a defense. Then you'd need to file a motion for summary judgment and say that based on everything, nobody disputes the facts, but we think that we have a valid claim. Let's say it's for a title objection. If nobody disputes the claims of the title company and they just think it's an issue of whether the law applies, you may be able to get a motion for summary judgment granted, which is also relatively quick. The third is that you got to settle in and you got to buckle up and pay a lot of money to go through discovery. You may have depositions. If you truly have a fact issue that the seller thinks that the damage is de minimis, the damage is just $10,000, and we have blown it out of proportion in claiming that it's going to be $500,000, and they are prepared to litigate because they will get their attorney's fees awarded, that is a rare scenario, but it could happen. And so anytime you go into litigation, anytime you have a conflict with another party over some money, you have to prepare that this could cost $20,000, $25,000 in legal fees to take this all the way through trial. I also want to add that you may have an award for attorney's fees if you get a default judgment. You won't get those paid out from the judgment, but you could abstract that judgment and file it in the county, and you could have a lien filed against the property against the seller for your attorney's fees. So it's not true to say you're forever out those attorney's fees, but you do have to front them, because I don't think there's any attorney that will take it on contingency, but you front those fees, and then you may have a claim to recover them from the seller when they eventually refinance or sell the property. And so that's it. Those are, I would say, the three most common outcomes, but you do have to prepare that a earnest money or a dispute in the real estate purchase transaction is going to be costly. There is no way around it. Involving lawyers and involving a dispute is not a fun process, and anytime there's a disagreement and you have to involve lawyers, it's going to be painful. But hopefully this video prepares you a little bit for that scenario and understanding what are the low, medium, and high outcomes, or worst, medium, and best outcomes at each stage. So smash that like button if you found this useful. Drop a comment if you guys have any more questions or if I didn't say something clearly, and we'll see you next time.